Hello friends, this is Sanjay. In this video series, I will be covering an overview of the Constitution of India as per the standard LLB syllabus. I will give you a high-level overview of the Constitution, that is, the big picture. Plus, we will also cover all the important articles and concepts. The latest PDF version of the Constitution is available at the URL on the screen. Download a copy and after every video, read through the relevant articles that we have discussed. If you have any questions or if you feel that I have missed covering something important, then post a comment and I will try to cover it in another video. The first question is, what is the Constitution? The simplest definition of the Constitution that it is the primary rule book for the country. It lays down the fundamental principles by which the country is governed. That is, it gives the basic principles that the government has to follow. We routinely come across many procedures and guidelines in both government and private institutions. These procedures and guidelines are based on some rules and regulations. These rules and regulations have to adhere to certain laws and statutes. These laws or statutes are made by the government using the powers that are given to the government by the Constitution. So the Constitution not only gives the powers to the government, it also provides the guidelines on how the powers can be used. Plus, it also lays down some restrictions to prevent the misuse of these powers by the government. To summarize, whatever may be the procedures and guidelines that we see around us, whatever may be the rules and regulations that we follow, or whatever may be the laws or statutes that are enacted by the government, all of them have to adhere to and stay within the framework of the Constitution. So, the Constitution is the primary rule book of the country. The Constitution is not just a legal document. It governs all the laws of the country, so it may be predominantly legal in nature. But it also has social aspects. For example, it attempts to reform the society by abolishing discrimination. It tries to emphasize the right to education. The Constitution also has political aspects. For example, it outlines as to how the overall system of democracy in India should function. It also has economic aspects. For example, it gives the right to citizens to practice any profession or carry on any occupation, trade or business. And it also gives the power to the government to levy taxes. In short, you can say that the Constitution affects every aspect of our life, from birth to death. If you look at the different types and concepts of Constitution from across the world, they can be classified on the basis of several attributes or qualities, such as it might be a written Constitution, like what we have in India or in the United States, where there is one document called the Constitution. This is also called a codified Constitution. Or it might be unwritten, like in the United Kingdom, where the Constitution is essentially an aggregate or a collection of several separate documents. It can be flexible, like in the UK, because their Constitution is not codified into a single document and it is a collection of several separate documents. If the Constitution needs to be amended, you just have to amend one of the underlying documents. So the Constitution in UK is very flexible. It can be a rigid Constitution, like we have in India or in the US, where many crucial aspects of the Constitution cannot be modified. For example, the basic structure of the Indian Constitution cannot be modified. While other aspects can be modified, we have to follow a very elaborate process to do so. It can be a federal constitution, where the power is shared between the center and the states. Or it can be a unitary constitution, where the center is supreme, like in the UK, because UK does not have any states. Even if there are states in a country which has a unitary constitution, the states will have very limited powers. It can be an evolved constitution, like in the UK, where the constitution has evolved or developed over a very long period of time. Or it can be an enacted constitution, like in India or in the US, where the constitution was drafted, ratified or enacted over a very short period of time. It can follow a republican model, where the head of the state and other important government officials are elected by the citizens, directly or indirectly. It can follow a constitutional monarchy model, where a hereditary king or a queen is the head of the state and the other officials are elected by the citizens. The Constitution can follow a presidential model, like in the US, where the head of the executive branch, that is the president, is the head of the government. Or it can follow a parliamentary model, like in India, where the head of the legislature, that is the prime minister, is the head of the government. Now, a point that is obvious here is that a country's constitution may have several of these qualities or attributes simultaneously. For example, the Indian Constitution is written, rigid, federal, enacted, republican, and parliamentary. What does the Constitution of India actually do? Well, it provides an outline for the government as a whole by defining the main institutions of the state, such as what is the legislature, what is the executive, what is the judiciary. It also defines the relationships and the interactions between these different arms of the government. It not only gives the powers that are required by these institutions, it also places some checks and balances and limits on the exercise of these powers, such as what laws can the legislature pass or what laws the legislature cannot make, and how the judiciary can or cannot interpret these laws, and what the executive can or cannot do while enforcing these laws. It also sets out the rights and duties of the citizens. It provides the framework for the interactions between the government and the citizens. For example, the right to information, which creates more transparency and allows citizens to look into the workings of the government, is given to us by the Constitution. It also creates some constitutional bodies, such as the Election Commission or the Finance Commission, which have a high degree of autonomy, since they derive their existence and their powers directly from the Constitution and not from the legislature or the executive. Since the constitutional bodies are under the President and not under the Prime Minister or the legislature, they can theoretically function without being influenced by the government of the day. For example, when the Election Commission is overseeing an election, they can function autonomously and not under the orders of the government or the party in power. What is the main purpose of the Constitution? This was probably best explained by Patrick Henry, who was an American politician and one of the founding fathers of the United States. He said that the Constitution is not an instrument for the government to restrain the people. It is an instrument for the people to restrain the government. He meant that a free government, that is, a democratic government that is working for the people, can be maintained only by frequently referring to or following a few fundamental principles, such as how the government should function, what powers it has, what powers it can exercise, and how. And these fundamental principles or basic principles are given by the Constitution. Look at the basic structure of the Indian Constitution. Without the rigid basic structure, which cannot be modified, which are the few fundamental principles which the government has to follow. If they were not there, then the government could modify anything in the Constitution as per their wishes, and there would be no control. So in short, the Constitution allows the people to form the government. It allows the government to function effectively, and it also allows the people to keep the government under control. How did the concept of a constitution evolve? Well, ever since there was any significant form of organized society, that is, ever since people started to live together in organized groups, there would have been some form of constitution, even if it was very rudimentary and unwritten. It might have been as simple as how is the leader of the group going to be chosen. In the ancient Hindu scriptures, such as the Vedas, the Upanishads, or the Dharma Shastras, or even if you look at epics like the Ramayana and Mahabharata, there is talk of Dharmatantra, Prajatantra, Rajatantra, which were the rules, the guidelines, or the best practices on how the government, the justice systems, and the society as a whole should function. Emperor Ashoka's edicts are also considered as milestones in the evolution of the constitution because they documented Ashoka's moral and religious beliefs and his social welfare programs. The edicts were based on Ashoka's ideas on administration and the behavior of the people in the society. So the edicts were a form of constitution that he wanted his kingdom to follow. During the Mughal period, the Farman-e-Shahi, that is, the proclamations of the emperor, acted as a constitution for the Mughal Empire. During the British Raj, there were quite a few acts that were passed. Initially, they intended to collect taxes and to control agriculture and trade in India. Later on, when the East India Company transitioned into the British Empire, there were some administrative acts that were passed, such as the Indian Council Act or the Government of India Acts. And finally, after independence, the Constitution of India, as it exists today, came into being. So this is an overview of how the Constitution evolved from prehistoric times to the modern era. When the Constitution of India was being drafted, there were several features that were borrowed from the constitutions of other countries. This was a very good idea because by studying constitutions from other countries, they could see what would work and what wouldn't work in the Indian context. By looking at what was already developed, they could include or build upon the features to make them suitable for the Indian social, political, and economic conditions. So, the best features from various constitutions were adapted into our constitution. For example, the concept of the concurrent list and the joint sitting of the parliament was taken from Australia. the concept of the republic and the ideals of equality, fraternity and liberty were taken from France. Emergency provisions came from the German constitution. Directive principles of state policy from Ireland. The functioning of the Supreme Court were from the Japanese constitution. The procedure for constitutional amendments was taken from South Africa. And several features such as the bicameral legislature or parliamentary privileges were taken from UK. The concept of written constitution, fundamental rights and judicial independence were taken from the United States. And the concept of fundamental duties was taken from Soviet Russia, which used to be called USSR at that time. What are some of the salient features of the Indian Constitution? Well, India has the lengthiest constitution among all countries. This was because there was an intention to put in writing as many things as possible to reduce ambiguity and clearly document the original intent. As we saw, it was drawn from various sources. There is a basic structure doctrine that is followed in the Constitution, which means that some aspects are rigid with limited flexibility and some features are flexible. And the Preamble of the Constitution, which essentially provides the basic structure, makes it quite unique. It follows a federal system where the power is shared between the center and the states with a unitary bias, which means that to a certain degree the center will still have more power than the states. And it follows a parliamentary form of government. The Indian Constitution promotes judicial supremacy, which means that the judiciary can nullify or reject any legislative or executive action if it goes against the principles of the Constitution. We also have a rule of law, and we also have an independent judiciary, which is again the reason behind judicial supremacy. Because the independence of the judiciary means that it can act without being influenced by the legislature or the executive. We also have directive principles of state policy. The Constitution also features some fundamental rights and duties. It promotes secular values. And India follows universal adult franchise, which means that all adults have a right to participate in the election process, either as a voter or as a candidate, with a few restrictions such as on convicts serving sentences in prison. Our Constitution also prescribes a single citizenship concept. And the Constitution also features some independent bodies or constitutional bodies such as the Election Commission to oversee essential functions of the democracy such as elections. It also prescribes a three-tiered government structure, that is government at the center, the state and local governments. There are also emergency provisions in the Constitution. And the fact that the Constitution declares India to be a union of states is also a unique feature. And it also talks about affirmative action. So these are some of the important salient features of the Indian Constitution. I will not go too much into the depth of these features now, because when we cover the various articles of the Constitution in this series, we will again be looking at each of these salient features in detail. Coming to the structure of the Constitution, it can be broadly divided into 4 sections: the preamble, the different parts of the Constitution, which are groups of related articles, the schedules, and the appendices. I strongly suggest that you should download the PDF copy of the Constitution from the URL on the screen and glance through it at least once. You should see what is contained in the schedules and appendices, especially because these are not discussed so frequently when we study the Constitution. The preamble is the first part of the Constitution, and even though the preamble is at the beginning of the document, it was actually adopted after all the articles. So in a way, the preamble summarizes the intent of the Constitution. The preamble is not unique to the Constitution, because if you look at most acts, there will be a preamble at the beginning which specifies the main intention of the act. Like this example from the Companies Act, which states that this is an act to consolidate and amend the law relating to companies. The preamble is a crucial part of the Constitution, especially since it is considered to be a part of the basic structure of the Constitution. In the 1973 Keshwananda Bharati case, the Supreme Court held that amending the preamble in any way that goes against the basic structure or negates some of the basic principles mentioned therein is not valid. Initially, there was a question about whether the preamble is actually a part of the Constitution, or was it just like an additional commentary. In the 1960 Berubari Union case, the Supreme Court held that the preamble is not a part of the Constitution. But this view was reversed in 1973 in the Keshwananda Bharati case decision, where the court held that the preamble is indeed an integral part of the Constitution and it is part of the basic structure itself. Now, if the preamble is part of the basic structure, and if we say that the basic structure of the Constitution cannot be changed, does it mean that the preamble can never be amended? Well, no, because the preamble can be amended and it has been amended once so far. In 1976, after the Keshavananda Bharati decision. If you look at the original preamble and the current preamble, the changes are visible. The original version said sovereign democratic republic, whereas the current version says sovereign socialist secular democratic republic. So these two words, socialist and secular, were added later. The original version talks about assuring the unity of the nation, and the current version talks about assuring the unity and integrity of the nation. So this word, integrity, was added here later. So these changes do not take away or negatively affect any of the previous basic principles of the Constitution. They only add to the basic structure and strengthen them. So these changes are valid. You would have noticed that we keep talking about the basic structure and the basic features quite frequently. So let me give a little more clarity on these two concepts. While we keep talking about the importance of the basic structure, there is no one single list or document or ruling that clearly says that this is the complete basic structure of the Indian Constitution. Instead, the concept is actually based on the judgments from across several landmark cases, such as the Kesavananda Bharati case, the Minerva Mills case, the Vaman Rao case, the Indira Gandhi re-election case, and a few others. The basic features of the Constitution are given in the S.R. Bommai judgment, where the Supreme Court stated that the preamble is an integral part of the Constitution and the basic features of the Constitution are democratic form of government, federal structure, unity and integrity of the nation, secularism, socialism, social justice, and judicial review. Now, if you look at the explanations about the basic structure in the landmark cases, they are all based on or can be derived from the list of basic features listed in the S.R. Bommai judgment. The only critical aspect that seems to be missing is fundamental rights. So to put it in a simple way, these basic features plus fundamental rights together form a major part of the basic structure of the Constitution of India. Now, all these basic features are mentioned or can be derived from the preamble itself. Democratic is mentioned here. Federal structure can be derived from democratic. Unity and integrity are mentioned here. Secularism is here. Socialism is here. Social justice and judicial review can be derived from justice. And fundamental rights can be derived from liberty. As per the basic structure doctrine, any amendment that tries to change the basic structure of the Constitution is invalid. So, any attempt to reduce the scope of the preamble or change whatever is listed in the preamble will be invalid. For example, the government cannot pass an amendment that India will be a communist republic instead of a democratic republic. It will be invalid because such a change will change the basic structure or the basic feature of the Constitution itself. The government cannot also declare that any specific religion will be the state religion or the national religion because it will be against the concept of secular which is given in the preamble. So, if you want to understand the basic structure of the Indian Constitution and list down the aspects that cannot be changed, just look at the preamble. You may occasionally see questions about the objectives and values listed in the preamble. The first one is we, the people of India, give to ourselves this Constitution, which means that this Constitution was given to us by ourselves and not forced on us by anyone else. The power and authority that the government derives from the Constitution has been given to it by the people. We are a sovereign country. This means that India is an independent country completely free from foreign control. And we have the authority to create our own foreign policies and deal with our own internal affairs. Socialist, which means that all citizens should have equal opportunities and the government will make all efforts to bridge the gap between the rich and the poor. And republic means that we are not ruled by any hereditary king or queen. We will elect our own government, directly or indirectly. Democratic, which means that the people will participate in the creation of the government through elections. Secular, which means that there will be no national or state religion. And there will not be any discrimination in the country on the basis of religion. Justice, which not only is a reference to the legal aspect, it also includes a broader concept of social, political, and economic justice. Liberty, which is essentially the aggregate of all the freedoms and rights guaranteed by the Constitution to all the citizens. Equality, which means that all citizens will be treated equally without any discrimination on the basis of factors like religion, caste, gender, or economic status. And fraternity, which means that we are one people and the dignity of every individual should be protected and the unity and integrity of the nation is of utmost importance. In some university syllabi, the term constitutionalism is also mentioned. So I will briefly explain the concept. It is actually quite simple. Almost every country will have some kind of constitution, but not every country will have the constitution as the ultimate rule book. In a democracy like India, the constitution is at the top, and anything that the government does has to be within the limits set by the constitution, especially since the government derives its power from the constitution itself. So in India, constitutionalism is the norm. In other words, India has a constitution and it is held to be the supreme law of the land. Whereas in a dictatorship, or in the case of an authoritarian or a military government, the dictator, the government or the military are at the top, and they will bend, break or rewrite the constitution as per their convenience. So the constitution is just like any other document. So constitutionalism means that a country has a constitution and it is actually following that constitution in letter and in spirit. Let us now move on to the articles of the constitution. Part 1 has 4 articles. Article 1 says that India shall be a union of states. There are a few union territories as well which are not full-fledged states. The territories of the state, that is what is the actual geographical area that is included in these states and the union territories, will be specified in the first schedule of the constitution. Now the significance of India being a union of states and not just a federation of states is that a union is a stronger framework, which means that India is one entity and the states cannot secede or separate out of the union. In a simple federation, the states may still have an option of going out separate on their own. Article 2 says that the Parliament may admit into the Union or establish new states. This article was actually used in 1975 to admit Sikkim into the Indian Union. Before it became the 22nd state of India, Sikkim was an independent kingdom. Article 3 gives the power to the Parliament to form new states. With the due process, the Parliament can alter the areas, alter the boundaries, or alter the names of existing states, or separate them or unite them to form new states. Article 3 has actually been used quite frequently in the recent past, when states like Telangana, Uttarakhand, Jharkhand and Chhattisgarh were created. Article 4 is more procedural in nature. It says that if the Parliament admits new states into the Union under Article 2 or uses any of the powers given to it by Article 3 to create new states, then the first and the fourth schedules of the Constitution should also be amended. As I mentioned, the first schedule of the Constitution documents the name and the geographical territories of the states. And the fourth schedule covers the allocation of seats for all states in the Council of States. Before moving on to the next part, which deals with the citizenship of India, I will briefly talk about 4 frequently used terms: residence, domicile, citizenship and nationality. A residence means the place where the person is staying physically. It can be short-term or long-term. Remember, when you apply for a SIM card or for your bank KYC, you have to provide proof of residence. Now, residence can be changed easily. Just shift to a new house and get your Aadhaar card updated and you have a new residence. You will see that in various laws and statutes, such as the Citizenship Act, the term residence has been used in the context of domicile, because long-term residence can be considered as domicile. Now, residence is also a prerequisite for Indian citizenship through naturalization. If a foreigner wishes to acquire Indian citizenship, then he or she should have entered and stayed in India legally for at least 12 years. Or if the person is married to an Indian citizen, then he or she should have entered legally and stayed in India for at least 7 years to be eligible. Now, residence can have an implication on taxation also. For example, for income tax purposes, your tax liability will differ depending on whether you are a resident and ordinary resident, or you are a resident but not ordinary resident, or you are a non-resident. Now, domicile is used in the context of the state or the country where the person has lived for a long time, that the person considers as a permanent residence. For example, if you apply for a domicile quota, then you have to show that you have studied in that state or you have lived in that state for an extended period of time. Then you have citizenship, which is a recognition that you are a member of a sovereign state. Though they are often used interchangeably, citizenship and nationality have different meanings. For example, if you are an Indian national, you will always be an Indian national. But you can become the citizen of a different country like the US or UK through naturalization. One key aspect of citizenship is political rights. That is, only citizens can participate in elections as a candidate or as a voter. Another key aspect is that citizenship is applicable to natural persons only. An artificial legal person like a company cannot have citizenship. They can have nationality based on parameters like incorporation, but a company can never have citizenship. Citizenship can be reversed or changed, but nationality can never be changed. And depending on the country, a person can have dual or multiple citizenships. But India does not recognize dual or multiple citizenships. Now, nationality is usually determined on the basis of where a person was born or where the person's parents were born. Normally, a person can have one nationality, even if the person has multiple citizenships. Now, nationality can be assigned to artificial legal persons also, such as companies. Some organizations, like the International Human Rights Codes, use these two terms, citizenship and nationality, interchangeably. In that context, if a person is a citizen of a country, he or she is considered to be a national of that country also. But this is something that we can discuss about in some other video. Part 2 of the Constitution consists of Articles 5 to 11, which are about the citizenship of India. These are relatively simple articles, so I will not go too deeply into these. I recommend that you should directly read these articles in the PDF copy of the Constitution also. As you will see, citizenship law in India largely follows the concept of jus sanguinis, that is, a citizenship by right of blood, rather than jus soli, that is, citizenship by right of birth. Now, Articles 5 to 8 talk about the acquisition of citizenship. Article 5 covers citizenship by domicile. It says that when the Constitution was commenced, if a person was born in India, or if either of the person's parents were born in India, or if the person was ordinarily resident in India for at least 5 years before the commencement of the Constitution, then the person will be a citizen of India. Article 6 covers the citizenship of people who migrated to India from Pakistan after the partition. Article 7 talks about people who migrated to Pakistan after partition but returned to India under any applicable permit or law and were legally resettled in India. And Article 8 talks about persons of Indian origin residing outside India, that is, persons whose parents or grandparents are Indian, and how these persons can acquire Indian citizenship by registering as such in the Indian consulate or the embassy. Of course, subject to some rules and procedures. Article 9 says that if an Indian citizen voluntarily becomes the citizen of another country, then that person will cease to be the citizen of India. Now, it doesn't matter if the other country allows for dual citizenship. It matters that India does not recognize dual citizenship. You would have heard of this Overseas Citizen of India or the OCI scheme. Now, this is not a dual citizenship. It is essentially a multi-purpose, multiple entry visa with no expiry date. Now, the OCI scheme provides a number of benefits in the economic, financial and education fields, but it does not allow for all the rights of a citizen. For example, it does not allow a person holding an OCI status to apply for a government sector employment, and it does not give the person the right to vote. And a person with an OCI status cannot acquire agricultural property in India. Article 10 says that citizenship does not have any expiry date. So, an Indian citizen will continue to be an Indian citizen indefinitely, unless citizenship is renounced voluntarily, or it is automatically terminated by statute, such as when the person acquires citizenship of another country, or the person may be deprived of citizenship by any applicable law. Article 11 gives the Parliament the power to regulate the right of citizenship by passing suitable laws, and this has been done through the Citizenship Act and its amendments. The Citizenship Act provides that a person can gain Indian citizenship in any of the following 4 ways: by birth, by descent, that is, because of parents or grandparents, by registration, or by naturalization. A person can lose citizenship by voluntarily renouncing it while taking up the citizenship of some other country. Even if the person does not voluntarily renounce Indian citizenship, it will be automatically terminated because India does not recognize dual citizenship. Or citizenship may be deprived by law in some cases, such as when a person has become a citizen of India through fraud, or if the person has worked with an enemy country against India during a war. Like we discussed earlier, the Constitution is the supreme rule book of the country, and any laws or statutes passed by the government have to be in accordance with the Constitution. And the government can pass laws or statutes only if the Constitution has given it the power to do so. Now, the Citizenship Act is a very good example of that. We can see that these provisions of the Citizenship Act can be linked back to the Constitution. by birth or by descent. These are covered under Article 5. By registration is covered under Article 8. Loss of citizenship through renunciation or termination are covered under Article 9. And the processes of naturalization and deprivation of citizenship are done through legislative actions, that is, through a law that is passed by the Parliament, using the power given to the Parliament under Article 11 of the Constitution. With that, we will conclude part 1 of this series. If you have any questions, or if there is anything important that I have missed, or if something is not clear, or you have any other feedback, then post it as a comment under this video. We will meet again in the next video. Till then, take care, stay safe.